Hello and welcome to this week's session of ELI Summer School Basics of the Clean Water Act. My name is Chandler Randall and I'm the Manager of Educational Programs here at the Environmental Law Institute, and I am so delighted to welcome everyone to this week's webinar. ELI is proud to offer programming on cutting-edge issues in environmental law and policy, and it is such an honor to have you join us today for this special program. Please join us each Thursday this summer for summer school sessions such as this one covering key topics in environmental law. At the end of today's webinar, we will have time for a Q&A session, so please submit your questions through WOTUS question box, and please do not wait until the end. Please send us your questions as soon as you think of them. I would like to thank our outstanding panelists for joining us today to lend their expertise to this webinar. And while they will be introduced briefly, the full speaker bios are posted on our website, eli.org, and I strongly encourage you to check out their expertise and experience in more detail there. As we begin, I would like to very briefly introduce today's moderator, Adam Schipp. Adam is a senior attorney and director of the Western Water Program at the Environmental Law Institute. Much of his research focuses on water resource management, specifically identifying opportunities to meet conservation and sustainability objectives through existing laws and potential legal developments. He leads ELI's work on water allocation and use in the US. Adam also has worked extensively on other topics, including TMDLs and the Clean Water Act 303 delisting, marine spatial planning, and ecosystem-based management of marine resources, and routine program challenges under the Coastal Zone Management Act. Adam, we are so thrilled to have you here with us today. With that, I will turn things over to our amazing moderator, Adam Schipp. Thank you all so much.
Great, the introduction, Chandler. Thank you very much. Hello, welcome everyone to this week's summer school course. We are very privileged to have three distinguished attorneys walking us through various aspects of the Clean Water Act, starting with a broad overview before detailing some of the more hot button issues of late. Specifically, Robin Rotman will recount the history of the water quality regulation in the US, provide a quick summary of the various aspects of the Clean Water Act, and then briefly touch on some current issues. Jonathan Genzier will then explain the history of the current state of affairs, regarding waters of the US, which is effectively the applicable jurisdiction of the Clean Water Act, and then talk about the new Section 401 rule, which concerns the review authorities of states and tribes relative to certain federal actions. And last but not least, Aaron Grisby will cover aspects of point and non-point source pollution, including the Maui decision, before explaining some of the basics of total maximum daily loads, or TMDLs. The session is going to conclude with a Q&A period, and hopefully we will have plenty of time to address any questions that you may have. To reiterate what Chandler just mentioned about the questions, please submit them as they arise to you and do so through the questions box. This will ensure a much more efficient transition to the Q&A period, but also if there's anything that's sort of a quick clarification for any of the presentation materials, I'll ask that in between the three presenters to try to make sure that that information gets addressed pretty quickly. So again, please submit your questions as they arise, and for anything that's quick, we will address it before we move on to the next presenter. Things that are going to be a little bit more substantively involved, we'll save to the end. So with that, I would like to introduce Robin Rotman. She is an assistant professor at the University of Missouri, having moved to academia after a decade of practicing environmental law at the Missouri Department of Natural Resources and at Van Ness Feldman LLP in Washington, D.C., where she continues to serve as counsel. Robin's primary interests are water resources and water quality, land use, and environmental justice. She earned her bachelor's degree in geology from Sewanee, the University of the South, her master's in water science from the University of Oxford, where she was a Rhodes Scholar, and her JD from Yale Law School. So with that, Robin, the floor is yours.
Thanks so much, Adam. And Chandler, thank you for the opportunity to participate today. It's great to see we have, I think right now, 261 participants, probably including undergrad students, law students, summer law clerks, associates. So it's great to see such a good turnout today for our discussion of the Clean Water Act. And let's see if I can be, there we are. Okay, so it looks like they've given me control of the slides. As Adam said, I'm Robin Rotman. I'm an assistant professor at the University of Missouri, and I'm going to be starting things off with a broad overview of the Clean Water Act, basically how it works, and also some commentary on how it doesn't work. Again, it's nice to meet you. I hope one day we'll be able to gather again in person. And I wanted to put in a plug for a program that ELI offers called the Emerging Leaders Initiative. So this is a program that I was previously a part of, and it is a cohort program for more junior practitioners in environmental law. And so it offers access to ELI programming, mentorship, fantastic networking opportunities. When I went through, it was during the COVID era, so entirely virtual, but it was still a great way for me to meet other peers and more senior practitioners. And also offer some professional development opportunities like writing an article or even giving a presentation such as this one. So if you would like more information, I'm sure that Chandler or Adam can provide more details, but I just wanted to note that was a program I had participated in and found quite valuable. So in terms of my presentation, we're going to do three things. First, I'm going to give a quick history of water quality regulation in the United States. So we're going to go all the way back to the Constitution and some very early case law that then leads us up to the Clean Water Act. So I'll discuss the main components of the Clean Water Act and how they work. And then I'm just going to tee up a couple of those current issues, like the Waters of the United States definition or the County of Maui case, which then Jonathan and Aaron will discuss in detail. And again, I look forward to your questions or your commentary during the Q&A period. Okay, so diving into the history, it all starts with the Constitution. And I know that we've all studied the Constitution, whether that be in elementary school or high school, or those of us who are attorneys, certainly we've taken constitutional law. But just a couple of principles to ground ourselves in as we look at the Clean Water Act and other environmental laws, which is, so we are a nation of states that came together and ceded certain rights to the federal government. So not every country is like that, but so we had states with states' rights, came together, delegated some of those rights to the federal government in the 10th Amendment of the Constitution. But this amendment says that those powers that the states did not expressly give to the federal government are retained by the states. And so over and over in environmental law, we see these questions of, well, what is within the proper purview of the federal government, like the EPA, and what is in the purview of the states? And that's a theme that comes up in particular in the Clean Water Act. The other key provision I want us to keep in mind is the Commerce Clause, which says that Congress, so the federal government, has power to regulate commerce with the foreign nations, among the states, and with the Indian tribes. And so this Interstate Commerce Clause has been used as a basis for federal jurisdiction over many different types of issues. We'll speak about it in the environmental context today, but I think perhaps more significantly, was in anti-segregation provisions. So when we hear back about, restaurants that would not admit people of a certain color or facilities that segregated people by color, it was the federal government's power through the Commerce Clause that had those state laws to be overturned. So let's dig into this question of, well, what does the Commerce Clause have to do with water quality? Well, it actually goes way back to some very early case law from the 1800s. So the first case I want to summarize is called Gibbons versus Ogden. And this involved some passenger steamship routes between New York and New Jersey, and the efforts by those states to regulate those steamship route rates. So the Supreme Court shut down those state standards on the basis that goods and services in interstate commerce that are transported by vessel is a matter of interstate commerce, and therefore only Congress can regulate those water bodies. And then about 40 years later, a case involving a bridge in the city of Philadelphia, some boat operators complained that the bridge was going to be an impediment to navigation. But the city wanted to construct it, and the state. The Supreme Court refined its position, saying that Congress, so not the states, but Congress, has the power to keep navigable waters open and free from any obstruction to navigation. and this was due to its Commerce Clause authority. So the first case that actually then defined navigable waters is the case called the Daniel Ball. And this had to do with a regulation of a steamship licensing in the state of Michigan. And the Supreme Court held that basically when we talk about navigable rivers for legal purposes, those are those which are navigable in fact in their ordinary condition using customary modes of travel. So basically this says, if you could float a boat on it, if you could actually conduct commerce in this water body, it's navigable in fact, and therefore also navigable in the eyes of the law. So some of the legislation that led up to the passage of the Clean Water Act also focused in on this navigable waters definition. The Rivers and Harbors Act of 1899 is often called the first American environmental law, and it made it illegal to dump refuse or debris into navigable waters without a permit from the Corps of Engineers. And so the basis here was, you might think, well, the Corps, we'll talk in a moment about the role of the Corps. We call this the first environmental law, but the motivation at the time was not necessarily environmental. It was to promote navigation. And as people were dumping trash into rivers and more urban areas, this was an impediment to boat travel. And so this act made it illegal to dump that refuse without a permit. That's really all we had on the books until the mid-1900s, when the Federal Water Pollution Control Act. Now, this was the first act that sought to do something about water pollution in the way that we think of it today. So not just debris that had been deposited and interfering with navigation, but actually pollutants that affected water quality. And so this act empowered the US Surgeon General to investigate and seek to enjoin, so seek to get an order from a court to stop water pollution that was originating in one state and affecting another. However, this authority was more limited than it sounds, because the Surgeon General could only do this with the consent of the state where the pollution originated. And probably not surprisingly, a lot of states didn't give this consent because they saw that it might negatively impact their industry, and they might not have really cared if this water pollution was ending up somewhere else. The Water Quality Act of 1965 is really the precursor to the modern Clean Water Act, and contains a similar structure. So it required states to identify the intended uses of navigable waters within their borders and set water quality standards that would support those intended uses. So this was more of a planning exercise. So it required that identification, the setting of standards, but it didn't actually require states to enforce those standards. And so without an enforcement mechanism, it wasn't a particularly effective law. And that brings us, if you might know the song, The Summer of '69, to a number of events that occurred in 1969 that really captured the public attention. So here I've had a picture of the Cuyahoga River in Ohio catching fire. Also one of the Rouge River in Detroit. I could have also put one of Lake Erie that also caught fire that same year. And then also looking at coastal issues, this is an oil spill off the coast of Santa Barbara, California. And so all these events happening in relatively close proximity brought the issue of water pollution more into the minds of the American public. And so more and more the electorate began demanding that the elected officials take some action to address this problem. Now, certainly this wasn't only Clean Water Act. The late 60s through the 70s was a time where many of the modern environmental laws were passed as public attention just grew generally regarding environmental protection. So that kind of takes us through the history, and now I want to go through some of the nuts and bolts of how the Clean Water Act works. Well, I would note that it's the Clean Water Act's 50th birthday this year. And so this is a great opportunity for us to reflect on where the act has been effective and what still needs to be done to address water pollution in the United States. So at the time it was passed in 1972, the Clean Water Act contained two main goals. First, to make all navigable waters safe for swimming and fishing, which remains a goal today. The second was pretty ambitious, eliminate all pollution discharges to navigable waters by 1985. Certainly didn't meet that target. We still haven't met it today. But as I'll describe, we have made some progress in controlling pollution discharges. So two main agencies. Overall, the U.S. Environmental Protection Agency is the agency charged with implementing most provisions of the Clean Water Act. And so when I talk about permitting with the non-point source and point source, it's the EPA that's really driving the train on that. However, as I mentioned, historically, there was an emphasis on navigation and navigability of waters for defense purposes. And that's why even today, the Army Corps of Engineers still plays a role in permitting. So the two big functions of the Clean Water Act are to protect ambient water quality. So this is water, the quality of water in the environment, like our lakes, our rivers, our streams. And this is what we'll focus on today. I did want to mention briefly, though, that there's a second key function, which is for the EPA under the Clean Water Act to provide grants and low interest loans and also technical assistance to municipal wastewater utilities. So you might have heard of the State Revolving Funds Program. This is a way that municipal wastewater treatment plant or sewerage districts can get access to loans and capital to make improvements to their infrastructure. Again, today we'll focus more on the water quality protection, but this is hundreds of millions of dollars every year. So these grants are not insignificant. Now, I want to take just one moment to distinguish the Clean Water Act from the Safe Drinking Water Act. So the Clean Water Act, like we said, protecting ambient water quality. The Safe Drinking Water Act, on the other hand, sets minimum standards for the water that comes out of our tap of public water systems. So here you can see I got my water bottle. I filled it up this morning. I filled this up at my home, public water system. And so this water would be regulated by the Safe Drinking Water Act. I would note that the Safe Drinking Water Act does not cover private wells. So perhaps if you're living in a more rural area, you have a private well. If that is regulated at all, it's probably regulated at the county level. Also, the Safe Drinking Water Act doesn't oversee bottled water quality. That is handled through the Food and Drug Administration. Okay, so but big picture, Safe Drinking Water Act, tap water quality. It also, though, regulates the injection of pollutants into the subsurface. And this is because there's a clear link between pollution injections into the subsurface and water quality that could be used for drinking water. And just like the Clean Water Act, it provides a financial assistance program, this time to drinking water utilities. The Safe Drinking Water Act was passed in 1974. And I would just take a moment to make an aside, which is that in that era, drinking water and ambient water were really seen as two separate resources. Likewise, surface water and groundwater were seen as two separate resources. Of course, now we have a better understanding of hydrogeology, the water cycle. We understand how water in the ambient environment affects the quality of the water we drink. But at that time, that scientific understanding was not as advanced as it is today. And this sort of bifurcation of issues still persists in the way that the regulatory regime is arranged today. Okay, so key functions: protect ambient water quality. So a three-step process is set forth in the Clean Water Act for doing that. The first two actually sound a lot like the 1965 Act, okay? Just slightly different terminology. So the first is to determine the designated use, okay, before it was called intended use, now designated use for all navigable water bodies. So that could be as a drinking water source, it could be for hydropower, it could be for irrigated agriculture, it could be for fishing and swimming, and so forth. And then setting water quality criteria to meet those designated uses. The Clean Water Act, though, goes further by implementing anti-degradation measures. So this is what gives the first two steps like the teeth through permitting, inspections, and enforcement. Now, you might have heard of the topic of cooperative federalism. We talked a little bit about federalism before, but this is the idea that the federal, state, and tribal governments work together to implement the environmental laws. And in fact, the Clean Water Act is often held up as kind of the poster child of cooperative federalism in the environmental context. And that's because states can apply for delegated authority to implement one or more of those three functions. And as it is today, actually all 50 states have some amount of delegated authority for designating uses and setting water quality criteria. And 47 states have authority to issue permits, conduct inspections, and do enforcement activities. That delegated authority was built into the Clean Water Act when it was passed in 1972. At that time, at the time of passage, the Clean Water Act didn't envision that Native American tribes would have a role to play. But through Clean Water Act amendments, tribes can now apply for treatment as state status, which basically means that they can apply, just as the states can, to implement one or more of the regulatory functions. And today, 80 out of the approximately 560 federally recognized tribes have that authority. So I said it's cooperative, though. The states and tribes can't just do whatever they want. They have to comply with certain minimum criteria that are specified by the EPA. So they have the ability to make stricter standards to say that they want to have a higher quality of water in their jurisdiction, but they can't drop below those federal minimum standards. The Clean Water Act recognizes two different types of pollution sources. Point sources, so these are like literally ones we can point to, like a pipe coming out of a factory or a pipe coming out of the wastewater treatment plant, as well as non-point sources. And these are more diffuse, like agricultural fields, highways, parking lot runoff. And I'll talk for a moment about how the Clean Water Act addresses each of these sources. And then this is a topic that Aaron will discuss in greater detail. So the point source control system is fairly straightforward. This is set out under section 402. And what this section says is that a permit from the EPA, called the National Pollution Discharge Elimination System Permit, NPDES permit, is required for point source discharges. And so on the prior slide, I have the factory here. So for most polluters, such as a factory, the NPDES permit will contain numerical limitations on how much of the various pollutants can be discharged. When it comes to the wastewater treatment plant, though, it's harder because those plants have to receive whatever is coming into the sewer. And so unlike a factory that has, like a well-established process for what they're producing, the wastewater plant is just receiving this water without even knowing what's in it. And so the permit, instead of specifying effluent limitations, it specifies the level of treatment technology required. So that would be whether primary, secondary, or tertiary wastewater treatment. And I'm happy to expand on that in the Q&A. And overall, Clean Water Act Section 402 has been effective at controlling point source pollution, which might explain why today the biggest threat to water quality in the US is actually non-point source pollution. Now, the awareness of non-point source pollution was built into the Clean Water Act at the start. Section 208 required states to develop these area-wide waste treatment management plans to address non-point source pollution. The idea, though, was that the federal government would give states a financial allocation in order to develop and implement these plans. But the program was defunded by Congress in the 1980s and is not relevant today. So there's two provisions that are relevant today. One is 303D, the total maximum daily load, and Aaron will discuss this in detail. But just in brief, I would say, so not all water bodies have a TMDL plan. It's only required for impaired waters, which are those that consistently fail to meet their water quality criteria. And so this looks at all the sources of pollution in the watershed, point and non-point source. For those water bodies subject to a TMDL, the NPDES permits that exist can be tightened to become more stringent, and there can be a limited issuance of new permits. On the non-point side, the main focus is encouraging states to encourage landowners to voluntarily adopt best management practices to reduce runoff, like installing riparian buffers. Section 319 also tackles non-point source pollution. And this takes the financial incentive approach by offering grants to states that design and implement plans for controlling non-point source pollution. Oh, I see the, Jayla, I see your question. I'd be happy to take that afterwards. So again, this is focused on voluntary measures, but states have broad discretion as to how they're going to implement their programs. And as long as they're showing some progress in controlling non-point source pollution, these federal funds keep coming in. But in the big picture, the Clean Water Act has not been very effective to controlling non-point source pollution. Now I'm giving my opinion. Okay, this is just opinion. You can disagree or agree or whatever. In my opinion, it overly relies on the carrots, like these voluntary financial incentives, and not sticks, like binding regulations. And in my opinion, the reason for this is that the industries that are the primary sources of non-point source pollution have a strong lobbying presence. So these could be agriculture, this could be the home builders, this could be the transportation sector, industries that have a strong interest in not seeing further regulatory measures imposed on non-point source pollution. And I'd also note, it's just harder, right? Like it's easier when you can look at a point and say, this is what's happening at the factory. We need to put on a certain control device. It's harder to identify and to address diffuse pollution sources. One other item I wanted to note, just to kind of round out this Clean Water Act 101, is the dredge and fill permitting requirements under Section 404. So going back to this origins on navigation, even today, a permit is required from the Army Corps of Engineers for discharging dredged or fill materials into navigable waters. Where this really comes up, I guess you could want to fill, the Missouri River, but that's not really where it happens. It really happens in the wetland context. Often when there's urban development, wanting to build commercial or residential development on areas with wetlands. And so this section says that to the extent possible, those impacts need to be mitigated on site. And if they can't be mitigated, there's the possible to essentially buy wetlands to be built somewhere else through wetland banking, which it calls compensatory mitigation. I know my time is running short, so I'm just going to tee up these two issues. So two big issues, like what is a navigable water, or what is a water of the United States? And further, what is a point source? So we saw that the early case law for navigability focused on navigability in fact, like can we float a boat carrying goods or passengers in commerce? But of course, if you think about it today, navigation of water bodies is not the only issue that's relevant to interstate commerce. Certainly water quality, like we could think about pollution from nitrogen or phosphorus that is causing algal growth downstream. Those are all issues that are also relevant to commerce, whether or not a boat is involved. And so over the past, well, at least 50 years, there has been just an unending pattern of litigation, rulemaking, litigation about the rulemaking, new rulemaking, litigation about the new rulemaking, about the old rulemaking, like it just goes in circles. And this becomes very difficult for everyone, right? So for the state agencies that implement permitting programs, for the regulated community, for environmental advocates, for engineers and attorneys that provide compliance assistance. And so I certainly believe that there is a need for a durable definition, so meaning one that's lasting, beyond the presidential administration. I think that that will be better for everyone. Aaron's going to talk about this seminal case of the County of Maui, which introduced this concept of a functional equivalent of a point source discharge. So it says that sometimes a non-point source can be the functional equivalent of a point source and therefore needs an NPDES permit. Didn't provide a lot of details on what constitutes a functional equivalent. Ultimately, the Supreme Court said it's a case-by-case basis. I just wanted to go kind of meta for a minute, which is, you know, why does this matter so much? Like, why do we even need to have this paradigm of this functional equivalent? Well, the answer is because we have inadequate regulation of non-point source pollution. And so I think that the court, recognizing that, was trying to find any way to get at this pollution, which is clearly having an impact on the environment, by creating this construct of the functional equivalent. I'll be curious to hear what Erin has to say in her remarks. So that's all I've got. I really appreciate your time and attention today, and I look forward to speaking with you in the Q&A.
All right, Robin, thank you very much. Before we move over to Jonathan, I do want to ask two quick questions that came in. And by the way, thank you everybody for the questions that you've been submitting. Several of them are lengthier. We won't get into that yet. We'll save them for the full Q&A, but I have two that are more clarifications that I think could be helpful to cover right now. One of them you saw, how do combined sewer and combined water and sewage systems in cities like Kansas City, Missouri pollute our river when there's flooding, or is there anything, sorry.
Yeah, I think I know where Jayla's going with this. So this question is about combined sewer overflows. So I wouldn't necessarily say sewage and water system, but it's two different kinds of sewers in the same system. So the sanitary sewer, which is like the sewage collection from our toilets and the things we flush down the drain, as well as stormwater, which is the rain that runs off of the river, parking lots or roof surfaces during rain. So cities like Kansas City, Missouri, especially older cities, have a combined system where the sanitary waste as well as the stormwater runoff ultimately go into one sewer that feeds the wastewater treatment plant. But when it rains heavily, all that volume exceeds what the waste treatment plant can handle. So in some cities now there's like holding pens. Washington, D.C., a great example, where they built these underground storage tunnels. But in some cities, they just don't have the capacity for this water, and it just gets discharged. And the effect is, after a rain, you could have raw sewage in the environment. As to the question, let me try to see if this is what Jayla was going at. So absolutely a problem. It's a hard problem to solve because this requires long-term investment in new infrastructure. And a lot of cities like Kansas City, also like St. Louis, Missouri, don't have that money all up front. And so they have worked out what's called a consent decree with the EPA and with the state regulators. So in this case, the Missouri Department of Natural Resources, that basically says like, okay, look, we know it's a problem. We can't fix the problem overnight, but we're committing to make certain investments every year in order to generate certain improvements in water quality in the long term. So I hope that it kind of explains how the combined sewer overflow process works.
And just to clarify, I think originally the concept of a combined sewer made some sense because then you were treating your stormwater before it went back into the system. It wasn't just flushing everything off the streets. But the problem comes when you get heavy storms, which unfortunately we're getting more and more of.
Absolutely.
The other question I want to ask quickly before we move to Jonathan is why wouldn't states allow the federal government to bear the cost of regulation? This goes back to your point about delegated authority.
Why wouldn't
404, 402, et cetera?
So is what the question is, hey, it costs a lot of money to actually operate a clean water program. Like my first job out of law school was here in Missouri, in the Missouri Department of Natural Resources, which is the Clean Water Act permitting agency for the state. And so we had a whole team of permit writers and standard setters and inspectors and enforcement people, and it that is a real cost that the state incurs. Well, I can say some reasons why I think in Missouri they made that choice, and perhaps why other states did as well. One, it is possible to recover some of those fees through permit fees. So if you apply for a permit, that is not necessarily a free or even a cheap process. So some of those fees can be recovered. Secondly, there's a notion that the local personnel have a better understanding of local issues and are going to do a better job treating local people in a fair and efficient manner. There's a sense that, like those big old bureaucrats back in Washington, like they're just so disconnected from what's happening on the ground. How could we trust them to be handling this issue, up in some rural county in Missouri? Now, you could debate whether that is sound policymaking or not, but I think that line of thought is common in most states, which is like, it's better for us to handle these issues locally and not have the EPA so involved.
And I would just quickly add to that. I think a lot of it comes down to that authority. We would like to do it. We want to have that power, that control. And going back to your point about tribes, there are about around 50 tribes that currently have water quality standard setting authority. About 3 years ago, the EPA developed guidelines for states or for tribes to be able to have Clean Water 303D authority. No tribes have yet sought that. And I think it is very much this balance of what's it going to cost? What are the expectations on us going to be versus what are the benefits and authorities that we will be getting out of it? And it is very much that balance.
And I think a tricky issue with tribes is, tribes are sovereigns that existed as sovereigns before the United States government existed. But the Clean Water Act doesn't necessarily always reflect that reality. And in order for a tribe to get this treatment of state status, basically it has to prove to the EPA that it has the infrastructure in place to implement an effective regulatory program. So it has internal governance, it has staff who are appropriately trained, and the EPA provides some funding in order to build that capacity. But it's quite a long and onerous process to prove to the EPA that a tribe is ready to assume that authority. So I'm not surprised that if a new authority was issued 3 years ago, even if some tribes have begun that process, the paperwork is probably still underway.
Thank you very much, Robin.
Thank you.
I would now like to turn things over to Jonathan Genzier, who is a staff attorney with the Southern Environmental Law Center in Charlottesville, Virginia. Jonathan primarily works on water-related issues. This has included coal ash, including 2 Clean Water Act citizen enforcement cases that went to trial, and interstate gas pipelines, including the now canceled Atlantic Coast Pipeline. His work currently focuses on water quality in Virginia and federal Clean Water Act regulatory matters, including rulemakings on waters of the US and Section 401 certification, which are the focus of his remarks today. Jonathan received his law degree and bachelor's degree from Vanderbilt. And with that, Jonathan, the floor is yours.
Thanks, Adam, and thanks to ELI for having me here today. When I was in law school, I worked on the Environmental Law and Policy Annual Review, which ELI publishes with Vanderbilt. So it feels a little bit like coming full circle. So thank you. I'd like to just tell you a little bit about SELC to start off. We're a nonprofit law firm that represents conservation and community organizations. We work in 6 states in the South. That's Virginia, the Carolinas, Georgia, Alabama, and Tennessee. And we've been involved in litigation over the scope of waters of the US and are advocating for strong federal clean water protections that are consistent with the goal of the Clean Water Act to restore and maintain the nation's waters. Next slide, please. So just to give you an overview of what I'm going to cover, as has been mentioned, so I'd first just like to discuss why the Clean Water Act's definition of waters of the United States, or WOTUS, matters, and then I'll walk you through the evolution of WOTUS through the various agency rules that have defined that term, and then talk about where we are today, which is awaiting finalization of a jurisdictional rule proposed by the Biden administration. I'll also touch on legal challenges to the prior administration's Navigable Waters Protection Rule, the status of the pending litigation on that, and just what to expect from the Biden administration. And then I'd also like to discuss proposed changes to the Section 401 certification rules under the Clean Water Act, give a brief overview of the ongoing litigation there, as well as the recently proposed 401 certification rule. Next slide, please. So why do waters of the U.S. matter? Why does the definition of that term matter? And I think you got a great preview of this from Robin. So waters of the United States is really a threshold term in the Clean Water Act. It establishes the geographic scope of the act, what waters and wetlands the Clean Water Act protects. So Clean Water Act regulatory programs address navigable waters, which the statute defines as waters of the United States. It doesn't define that term. It leaves that to EPA and the Corps to define. But that statutory term is the jurisdictional linchpin for just about every one of the critical safeguards for water quality that is contained in the Clean Water Act. Next slide, please. So why does that matter? Well, if you think about wetlands, they provide a lot of services that are quite important. They filter pollutants, they act as a sponge and absorb flood waters. They counteract surface water runoff and sedimentation. They protect the coast from erosion. They're nurseries for a lot of species, providing habitat. They recharge groundwater supplies. So both locally and within the context of a watershed, wetlands are quite important. Next slide. Streams as well. So including headwater streams, there are intermittent streams that flow only part of the year, ephemeral streams that flow in response to precipitation. These provide many benefits as well. Some are similar to the functions of wetlands, protecting against floods, filtering pollutants, providing habitat. They also transport water and sediment and organic matter and nutrients, as well as pollution, to downstream waters. And so the biggest rivers that we are all familiar with are only as healthy as what flows into them from upstream. Next slide, please. And just to introduce another concept, a jurisdictional determination is a determination by the EPA or by the Corp of Engineers whether a given project site has waters of the United States present on site. And these decisions are generally good for 5 years. So once you have your approved jurisdictional determination, you have a sort of a safe harbor for pollution or destruction of non-jurisdictional waters as set out in that determination, regardless of regulatory changes. So even if the definition of WOTUS changes within 5 years, you've sort of locked in the impacts that are set out there. Next slide, please. So as this timeline shows, the scope of the waters, which includes wetlands that have been subject to Clean Water Act jurisdiction, has really ebbed and flowed over the years with changes in administrations and with Supreme Court decisions. Next slide, please. So beginning with the enactment of the Clean Water Act in 1972, the Corps and EPA have defined waters of the United States by regulation. There has been ensuing litigation over the application of those rules, as well as responsive Supreme Court decisions and regulatory changes. So in the interest of time, I'm not going to do a deep dive into every aspect of this, but it does give you a sense of the history here. Next slide, please. So there are really 3 key Supreme Court decisions that, if you've taken environmental law, you have likely heard of. And those are Riverside Bayview Homes, Swank, and Rapanos. And these have been really critical as the definition has ebbed and flowed over the years. Next slide, please. And the agencies have responded to these Supreme Court decisions in between rulemakings by issuing guidance as well. Next slide, please. So, and Robin covered this very well. The focus of the pre-Clean Water Act laws that focused on navigability was really preserving the navigability of the nation's waters for commerce. By navigable, they really meant navigable. The water had to be currently used for transport or historically used for transport, or potentially could be used for transport in interstate or foreign commerce. And so that definition is that refers to what you may hear me refer to as traditional navigable waters. Next slide, please. After the 1972 Clean Water Act, the Corps issued the first Waters of the U.S. rule, and this limited jurisdiction to traditional navigable waters only. So, those main stem rivers and lakes and the oceans that could be applied for commerce. And so environmental groups considered this definition to be too narrow. And so the Natural Resources Defense Council sued the Corps of Engineers. And in a 1975 decision, the court agreed that jurisdiction was not limited by the traditional test of navigability, but that Congress intended jurisdiction under the Clean Water Act to extend to the maximum extent of Congress's Commerce Clause authority. Next slide, please. After this, the Corps amended its regulations, and then later Congress amended the Clean Water Act in 1977. And so there was further debate in Congress about the extent of the scope of the Clean Water Act. And I think it's notable that Congress did not limit the definition of navigable waters or waters of the United States, and it didn't otherwise reject the Corps' expanded regulatory definition post-Callaway. In 1982, the Corps refined its regulations yet again. It didn't significantly expand jurisdiction there, but it did add some exclusions, some of which remain today, like the exclusions for normal farming, silviculture, and ranching practices, and for water treatment systems. Next slide. So the first of these three Supreme Court cases began because a housing developer placed fill in preparation for constructing homes in 80 acres of marshes near the shores of Lake St. Clair in Michigan. And the Corps obtained an injunction in federal district court, which the Sixth Circuit Court of Appeals then reversed, saying that the wetlands did not receive frequent flooding by nearby navigable waters, and so were not jurisdictional. And in a unanimous decision, the Supreme Court reversed the Sixth Circuit, and it agreed with the Corps that the Corps had jurisdiction over the wetlands. The court said that the term navigable, as used in the Clean Water Act, had what it called limited import. And so the court described its decision, though, as being compelled by the language and the policies and the history of the act. And this was the first place where the Supreme Court came out with what would later be referred to as the significant nexus test, where the Corps appropriately asserted jurisdiction over wetlands with a significant effect on water quality and the aquatic ecosystem. Next slide, please. So in that recodification in 1986 by the Corps, it included what the agency called a clarification that waters of the United States actually included waters used as habitat by migratory birds that cross state lines or are protected by the Migratory Bird Treaty Act. And so you can see that commerce connection here. And so this was sometimes called the Migratory Bird Rule, and was at issue in the next Supreme Court case. Next slide, please. So this Solid Waste Agency of Northern Cook County, shorthand SWANC, involved an attempt to build a waste facility on an abandoned sand and gravel pit in northern Illinois. And I think it's worth noting the pit was not navigable. It didn't cross state lines. It was not adjacent to another jurisdictional water. It was geographically isolated. And under the Migratory Bird Rule, the Corps asserted jurisdiction and denied the application for a permit. And so this eventually reached the Supreme Court, which in a 5-4 decision rejected the Corps' assertion of jurisdiction because it rested solely on the fact that the pit was used as habitat for migratory birds. The Supreme Court said that that by itself was not enough, and it reiterated that the significant nexus between wetlands and navigable waters was what had informed its reading of the Clean Water Act in the Riverside case. And it found that that nexus just was not present here. Next slide, please. And so just in the interest of time, we'll go ahead one more slide. So as we moved into the 2000s, the agency started to focus more on science, updated scientific knowledge, and learning more about what it means for water to have a, quote, significant nexus. Next slide, please. So to date, this is the most recent Supreme Court decision on waters of the United States, or PONOS. And it arose from two consolidated cases. In both of those cases, the Corps had asserted jurisdiction over wetlands at issue, not because they were adjacent to traditional navigable waters, but because they were adjacent to non-navigable tributaries of navigable waters. So sort of one step removed from being adjacent to navigable waters. And in both of these cases, jurisdiction under the Clean Water Act was upheld by the district court and by the Sixth Circuit. And so the opinion here is fractured. The court did vacate the lower court decisions upholding jurisdiction, and it remanded both of these cases to the Corps for reevaluation under the 1980s regulations and consistent with the court's opinion. But two tests for jurisdiction arose from Rapanos. So first, in the plurality led by Justice Scalia, their test covered only relatively permanent waters that are connected to traditional navigable waters and wetlands that have a continuous surface water connection to those waters. Next slide, please. In contrast, the second test was announced by Justice Kennedy in a concurrence, which built on the past two cases that we talked about and extended jurisdiction to non-adjacent or geographically isolated wetlands with a significant nexus to traditional navigable waters. So for a wetland to possess the requisite nexus for jurisdiction, it either alone or in combination with what Justice Kennedy calls similarly situated wetlands in the region, has to significantly affect the chemical, physical, and biological integrity of traditional navigable waters. Next slide, please. So although the four dissenters in this case would have actually affirmed Clean Water Act jurisdiction, they agreed with Justice Kennedy that the plurality opinion was inconsistent with the text and the structure and the purpose of the Clean Water Act. Next slide, please. So after Rapanos, the agencies issued guidance to try and apply this decision on the ground. And under that guidance, waters of the United States included traditionally navigable waters, wetlands that are adjacent to traditionally navigable waters, and then waters that satisfied either of the two jurisdictional tests put forward in the Rapanos decision. Next slide, please. So following this, the Obama administration promulgated the 2015 Clean Water Rule, which was heavily reliant on the science of connectivity between waters. This was a 4-year rulemaking process. There was a large empirical record, and they used the record to determine which waters satisfied the significant nexus test to mandate inclusion as waters of the United States. And specifically, the rule identified 8 categories of waters that are covered as waters of the United States. So the first 3, long regulated traditional navigable waters, interstate waters, including interstate wetlands, and the territorial seas, any impoundments of those waters or tributaries of those waters as well. Prior regulations had included wetlands that were adjacent to other waters of the United States and defined adjacent to include bordering, contiguous, or neighboring. But the Clean Water Rule included adjacent waters as opposed simply to adjacent wetlands. and it defined waters as neighboring based on distances between waters and features of other jurisdictional waters like the 100-year floodplain, the high tide line, the ordinary high water mark. Next slide, please. So the Clean Water Rule also included some basically categorical protections where it enumerated certain categories of geographically isolated wetlands. And so these wetlands were said to be waters of the United States if determined on a case-by-case basis to have a significant nexus. So there's case-by-case. However, the rule clarified that for the purpose of the significant nexus analysis, those wetlands are similarly situated and should be combined with others in the watershed. Next slide, please. So I'll talk briefly about where we are today. The Trump administration promulgated the Navigable Waters Protection Rule, which has since been invalidated by a couple of courts. Next slide, please. The Trump administration's rule, they engaged in a two-step rulemaking process, but their Navigable Waters Protection Rule, which substantively defined Clean Water Act jurisdiction, next slide, please, excluded all otherwise jurisdictional waters, including traditionally navigable waters, if they fit within the rule's exclusions. So one example here is the expansion of the waste treatment system exclusion, so that traditionally navigable waters used as cooling ponds are excluded from Clean Water Act jurisdiction, even if they're used for drinking water or public recreation and in interstate commerce. Next slide, please. The rule categorically excluded ephemeral streams. It adopted the Rapanos plurality's emphasis on permanent flow. And the agencies acknowledged in the rulemaking that even some intermittent and perennial streams would be eliminated from jurisdiction. Next slide, please. The rule also severely restricted wetland protections, and it emphasized the need for a wetland to touch or have a permanent surface water connection with a jurisdictional water as defined by the rule. Next slide, please. So according to data from EPA on the actual implementation of this rule, 92% of waters that were considered in issuing approved jurisdictional determinations were found not to be jurisdictional, not to be protected by the Clean Water Act. Next slide, please. This is just a map of 563 non-jurisdictional determinations. We've talked some previously about downstream effects of pollution and interstate effects. So the red dots show sites where the waters on site were determined not to be protected by the Clean Water Act in watersheds that flow into another state. I think that illustrates that issue, that the downstream state is left powerless to regulate the discharge flowing in from upstream. Next slide, please. Okay, so as I mentioned, 2 district courts vacated the rule. There were a number of challenges to the Navigable Waters Protection Rule. Some of these have been remanded without vacature, others have been stayed, and we don't expect a merits decision in any of the still pending cases. Next slide, please. So last summer, almost exactly a year ago, the agencies announced their intent to initiate a new rulemaking process to restore the pre-2015 Clean Water Rule protections. So not going back to the Clean Water Rule, but going back to what it was in place before that. Next slide, please. So the proposed rule came out in December of last year, and the comment period closed in February of this year. Next slide, please. So under the proposed rule, waters of the U.S. includes the traditional navigable waters, interstate waters, and territorial seas, and adjacent wetlands to those, most impoundments of waters of the U.S., and tributaries, wetlands, and other waters that meet either the relatively permanent or the significant nexus standards from the Rapanos rule. Next slide, please. We'll go ahead to the next slide as well. So I'd be remiss not to mention a pending Supreme Court case on this issue, Sackett v. EPA, involves construction or attempted construction of a house in Idaho where wetlands were filled that had been considered jurisdictional under all prior rules except for the Navigable Waters Protection Rule. The district court granted summary judgment to EPA when that finding of jurisdictionality was challenged, and that was affirmed by the Ninth Circuit. The Supreme Court then granted cert, and briefing is underway now. Next slide, please. So the appellants in this case have asked the court to adopt a two-part test for jurisdiction. Is the wetland inseparably bound up with a water by a continuous surface water connection? And two, is the water that they refer to subject to Congress's authority over channels of interstate commerce? This is arguably more restrictive than the Scalia test set forth in Rapanos. Next slide, please. The government has argued that there's no sound basis for imposing a rigid continuous surface connection requirement, and that the significant nexus test is a permissible basis for identifying protected adjacent wetlands. Next slide, please. So I'm aware I'm running short on time, and I'd like to just give you an overview of a different Clean Water Act topic, the 401 certification rules. So this is the mechanism under the Clean Water Act for states to review and condition projects with federal licenses or permits to ensure that they will comply with state water quality standards. Some of the projects where a Section 401 certification is required include dams permitted by FERC, interstate oil and gas pipelines. Also, this is required for dredge and fill permits under Section 404 of the Clean Water Act. Next slide, please. So the certification has to include conditions that will ensure that the applicant will comply. Next slide. There we go. Will comply with enumerated provisions of the Clean Water Act itself, and then any other appropriate requirement of state law. It also sets out a reasonable period of time not to exceed 1 year for the certifying state to take action on a request for certification. Next slide, please. So why is this important? It's used by states to protect aquatic life and natural resources, to protect those designated uses of their waters. The certification can be either issued or issued with conditions, or denied or waived. And once issued, any conditions in the certification become a condition on that federal license or permit. And importantly, if the state denies the certification, then no license or permit can be granted. Next slide, please. The Trump administration issued a rule on Section 401 certification in 2020 that severely restricted state and tribal authority to impose conditions, the scope of their review of projects, and the timing that they had to do that review. Next slide, please. There were a number of challenges to this 2020 rule. One important issue was there is Supreme Court precedent that allows states to review the activity as a whole, not merely the triggering point source discharges that trigger the certification requirement, and states' ability to review other aspects of the project and their impact on state water quality was curtailed by the 2020 rule. Next slide, please. So here's just a list of some of the allegations in the various lawsuits challenging the 2020 rule. Next slide, please. So current status here in the Louisiana v. American Rivers case, which is pending in the Ninth Circuit, the Northern District of California vacated the 2020 rule and remanded it to the agencies. The Ninth Circuit declined to stay that vacature while the appeal is pending. However, the Supreme Court did issue a stay of the vacature order, and it has effectively reinstated the 2020 401 certification rule while the appeal is pending in the Ninth Circuit. Interestingly, the plaintiffs, if you will, blue states, tribes, and environmental groups challenging the 2020 rule have now moved for an indicative ruling in the district court. And so they're asking the judge there to allow the case to move forward to the merits. And that looks like it has now been fully briefed as of June 7th and is awaiting a decision by the judge. Next slide, please. So the Biden administration has moved swiftly to promulgate a replacement rule here that came out on June 9th, and it appears to restore much of the state and tribal authority under the Clean Water Act to review these federally licensed projects. Next slide, please. Just a couple of highlights from the rule as proposed. It clarifies that the triggering discharge is from a point source to a water of the United States, but that no addition of a pollutant is needed. And that's consistent with Supreme Court precedent and is important in the context of things like dams that may be discharging water that has an impact on state water quality, but is not in fact adding a pollutant to that water. It also allows states and tribes to place conditions on the activity as a whole that's being reviewed, and that includes impacts to non-federal waters once that point source discharge to a water of the United States is triggered. Also requires submission of a draft of the federal license or permit itself to the certifying authority. That's something that was not previously required and would appear to allow states and tribes to have access to more information about potential impacts to state waters. Thank you very much, and I look forward to discussing your questions later.
Thank you very much, Jonathan. Just two quick clarifications here before we move on to Aaron. One is similarly situated defined by Kennedy? The phrase similarly situated. Do you recall?
I don't recall. I believe that it's he may provide some detail about what that might look like, but it's going to be left to the agencies to formally define that.
Okay, thank you. And the other was just a clarification that the Sackett case is indeed ongoing. Is that right?
That's correct. And oral argument was just scheduled, I believe, for October 3rd, if I remember correctly.
And one more just came in. Does the proposed Clean Water Act regulation include discussion on PLA wetlands? There may have been an error. I don't know what PLA wetlands are.
Okay, I'm not certain either.
Okay. All right. We'll come back to that. If someone, Leslie, if you're able to clarify that, that would be great. And we'll address it in the main Q&A. All right. With that, I would like to, first of all, thank you, Jonathan, and now hand things over to Aaron Grisby. So Aaron is an associate at Hunt Andrew Kurth and part of their environmental practice group. She advises clients on regulatory and compliance issues with a specific focus on clean water, on the Clean Water Act. Prior to joining the firm, Aaron was an attorney at EPA headquarters in the Water Enforcement Division and the Air Enforcement Division of the Office of Enforcement and Compliance Assurance. She also has worked in several U.S. Department of Justice branches and at the White House Council of Environmental Quality. Aaron received her law degree from the University of San Diego School of Law and her bachelor's degree from UC Santa Barbara. And with that, Aaron, the floor is yours.
Thank you. So today I'll be discussing point sources, non-point sources, and total maximum daily loads. And so I know we're I'll kind of go through this all quickly. I know we're a little bit behind on time and answer your questions to leave some time to answer your all's questions. So next slide. As mentioned already, Section 301 of the Clean Water Act makes the discharge of any pollutant by any person unlawful, except as in compliance with a Section 402 or 404 permit or certain other permits, limitations, and standards. So the discharge of any pollutant is defined by the Clean Water Act to mean any addition of any pollutant to navigable waters from any point source. Pollutant, you'll see here, is defined quite broadly. covering everything from sewage, dredged soil, rock, chemical waste, industrial, municipal, and agricultural waste. Next slide. And the Clean Water Act goes on to define point source also quite broadly. You'll see, you can read there all the different categories, which also include CAFOs, which I'll mention later. So effectively, any discrete conveyance, such as a pipe or man-made ditch, is a point source under the Clean Water Act. The definition excludes agricultural stormwater discharges and return flows from irrigated agriculture. However, the Clean Water Act does include stormwater runoff as a point source from industrial and construction sites over a certain size. From CAFOs, CAFOs are animal feeding operations that meet certain conditions. And it also includes stormwater runoff from certain municipal areas under what are known as MS4 permits. Next slide. So as I mentioned, under the Clean Water Act, discharge pollutants are allowed so long as they are permitted. So the NPDES, the National Pollution Discharge Elimination System, controls discharges of pollutants to our waters. I'm not going to focus too much on permitting, but I just wanted to go over a little bit here on some of the two basic permits. The NPDES permit is one of the primary ways the U.S. controls water pollution, as Robin already mentioned. So you must obtain the NPDES permit before discharging a pollutant to waters of the U.S., which is what the water of the U.S. is controversial, as Jonathan just went through. So these permits are 5-year-long permits. That's the term. They need to be renewed after that. You may see some permits renewals happening after the 5-year mark, but the permit itself continues on until sometimes while they're sorting out a renewal. The permit can be an individual permit or a general permit. And what that means is an individual permit would be site specific and with conditions that address a particular facility or location issued to an individual permittee or co-permittees that are co-located at a site. For a general permit, this would be a permit that's issued by the permitting authority generally. And then those that fit the contours of the permit can apply for coverage under the permit. So multiple entities would apply for coverage under the permit, under one general permit. Either EPA or state energy agency can administer the NPDES program. And I think today there's less than a handful of states that haven't taken over administration of their own programs. This just outlines a few of the different programs. The municipal and industrial permit program, Robin mentioned some aspects of the municipal program dealing with the sewer systems and combined sewer systems for sanitary sewer systems. The pretreatment program ties in with those publicly owned treatment works handled by the municipalities. The pretreatment program serves to protect the treatment facility. So the facility might not be designed to handle certain types of waste streams or pollutants. So an industrial user would need to treat their wastewater prior to discharging to the local wastewater system under the pretreatment program. Federal facilities also have to comply. And you'll see here, there's also aspects that deal with the biosolid sludge program, under which certain solids are separated during the municipal treatment process. And those are used for land application, such as for non-food crops, for landscaping, or they're taken for surface disposal. And so there's part of the program, make sure that those are handled correctly. And then there's interplay with the Corps. Jonathan mentions some of this. So under for the Section 404 permits are for dredging and fill permits. And as Robin mentioned, these are kind of, dating back to the very beginning of our environmental laws, whereas the dredge and fill program. And these require the permits if you're going to discharge or direct material to waters of the US. The Corps issue these permits. EPA generally enforces. EPA does have veto authority. It can veto these permits. These can be general or individuals as well. There are some exclusions laid out in the law, and here they are listed here. But then those exclusions don't apply if the activity nevertheless brings navigable waters into a use that it was not previously subject to, that changes the flow, the circulation, or reduces the reach of the waters. Next slide. As far as the content of an NPDES permit, what you're going to find in each permit will be what we commonly refer to as T-bells or Q-bells. So you're going to have your technology-based effluent limitations. These are established by the EPA. They're particular to an industry. They seek the greatest pollutant reductions economically available or achievable. And so they are numeric limitations for a specific pollutant that reflect a certain level of control. So while they're called technology-based effluent limitations, they don't prescribe the use of a specific control technology. You'll also see water quality-based effluent limits in these permits. These are set by the states. They're based on designated beneficial use or uses for the particular water body. And here I've listed a couple of those uses: recreation, water supply, industrial, or other. The water quality-based limitations can be numerical or they may be narrative, and they provide the maximum concentrations of various pollutants that would not interfere with whatever the designated uses are for the particular water body. You'll also find monitoring and reporting requirements. There may also be special conditions for additional monitoring, special studies, best management practices, or compliance schedules, especially if there had been some prior violations that need to be incorporated into the next iteration of a permit. Next slide. So the water quality based effluent limits and the permits are based on water quality standards. And so as explained in Title 40 of the regulations, water quality standard defines the water quality goals of a water body or a portion thereof by designating the use or uses to be made of the water and by setting criteria that protects the designated uses. So the regulations also say that wherever attainable, they should provide, the water quality standard should provide water quality for the protection of the propagation of fish, shellfish, wildlife, and for recreation in and on the water. States, territories, and tribes adopt water quality standards for all waters of the US, and EPA has oversight authority. So there's pretty much three elements to water quality standards. There's designated use, and there you have it listed there. Then there's the water quality criteria, which I mentioned you find inside the permit. And there's also the anti-degradation policy, which Robin touched upon, that protects existing uses and the water quality so that it does not degrade. Next slide, please. So I spoke about those, I pointed out those water quality standards because they're part of the content that's in the NPDES permits, but I'll come back to those because they're relevant to something we're going to talk about later on. But relevant to point sources. So one of the more recent developments in point source regulation was the County of Maui versus the Hawaii Wildlife Fund case, Supreme Court case in 2020, which I'm sure most of you have already heard about by now and gone through. And so that set forth the functional equivalency test that helps determine whether migration of pollutants through groundwater is the functional equivalent of a direct discharge from a point source requiring a permit. And that, so they adopted that test. And so this is going to help discriminate between what is point source and what is not a point source for purposes of Clean Water Act permitting. So it's a very fact-specific analysis, but the Supreme Court provided a list of 7 non-exclusive factors. So here they are listed here. They look at the transit time for the pollutant to get to the water of the US from the point source if it passed through the groundwater, the distance that it had to travel, the nature of the material through which the pollutant traveled, the extent to which the pollutant is diluted or chemically changed as it travels, the amount of the pollutant entering the navigable waters relative to the amount of pollutant that leaves the point source, and the manner by or area in which the pollutant enters the navigable waters, and the degree to which the pollution at that point has maintained its specific identity. So the court did note that time and distance would be the most important factors in most cases, but not necessarily in every case. So this decision continues to have major repercussions on Clean Water Act liability cases. It certainly did for cases that were pending at that time. Next slide. We'll go through a little bit of the arguments, probably as a refresher to some. So the defendants, among other things, argued pretty much the terminal point source theory that the pollutant didn't come from their facility, rather it came from the groundwater. And so since it didn't come exactly from their facility to the waters, that it was not within the Clean Water Act coverage. So the majority opinion rejected that terminal point source theory. They also rejected the Ninth Circuit's standing fairly traceable test. They found the fairly traceable test is overly broad, though, and they found that the defendant's argument that rejected for kind of the terminal point source theory, providing total exclusion from Clean Water Act coverage, was also objectionable. So the majority noted that their new functional equivalent test was in line with EPA's prior practices, even though at the time of the opinion, EPA had changed its interpretation. And you can see that EPA's 2019 interpretive statement right there down at the bottom. The EPA, although, let's see, in practice, I believe they had allowed for, let's see, they had allowed for, let's see here in my notes. Oh, if there was, they actually had prior versions of discharges that reached groundwater only after lengthy periods of time. But they also did permit for situations where the discharge had gone through groundwater. But then their 2019 statement was different. It said that the Clean Water Act is best read as excluding all releases of pollutants from a point source to groundwater. So regardless of any hydrologic connection between the groundwater and the jurisdictional surface waters. Justice Kavanaugh concurred, but he concurred and made it clear that Scalia's plurality opinion and Rapanos would have reached the same conclusion, that you didn't have to create this new test effectively, but he did agree in the result. Justices Thomas and Gorsuch dissented. They looked at Rapanos and they said Rapanos was different and actually perhaps would not have reached the same result because Rapanos, they addressed, it was a chain of point sources, which in this case, the groundwater, in their opinion, would not have been part of a chain of point sources. Those dissenters favored the direct discharge theories, and they felt that the majority opinion that set up forth the 7 factors to consider lacked proper guidance and would potentially lead to inconsistent application. Justice Alito also dissented. He also felt there was a lack of clear guidance. He favored more of a direct discharge, but his theory of direct discharge was slightly different than those other dissenters. And he noted specifically that supplemental state authority would be able to regulate groundwater so that there was no need for EPA to necessarily reach so far. Next slide. So looking at the aftermath of Maui, In January of 2021, EPA issued a guidance applying the Supreme Court's Maui decision. And so then not too long later, the Biden administration rescinded that document under his EO 13990. They rescinded the prior guidance because they said the guidance had added an 8th factor on the design and performance of the system or facility from which the pollutant was released. And they said that that additional factor was not consistent with Maui because it added an element of intent. So what you have now today are courts and permitting authorities applying these factors in practice. Since Maui, you had, I'll just give a couple examples. There was a district court in Montana. They actually requested each party brief them on each of the 7 Maui factors in 30 words or less. And then they added an 8th factor. And this 8th factor was whether or not there could be some other contributing source for the pollution that was at issue in that case. You can see here, there's the permitting authorities are having to grapple with this. I think it was a pollution control agency, I want to say Minnesota in 2000, I think this maybe earlier this year, faced remand. They issued a permit and the Minnesota appellate court remanded the permit back to them because they had not considered the Maui factors. Next slide. So that was kind of the latest, developments in point sources. Now turning to non-point sources. Non-point sources are defined by exclusion. So they mean any source that does not meet the section 502.14 definition of point source. So there is no Clean Water Act definition of non-point source, and causes of non-point pollution are runoff that can be from different types of precipitation, atmospheric deposition, drainage, seepage, or hydrologic modification. So the sources of this sort of pollution are diffuse. Here, I've named a few here. So residential and agricultural sources would be fertilizer, herbicides, insecticides that are excess, or bacteria and nutrients from livestock, pet waste, or faulty septic systems. So you all can help by making sure your pet waste goes where it should. You have a pet. Then there's also other urban energy like oil and grease type of runoff pollution. And then other natural construction and forestry sources would be sediment, erosion, channelization. And then the atmospheric deposition is air pollutants that deposit back onto the land or the water through precipitation, falling particles, or gas absorption. As Robin mentioned, non-point sources are the leading remaining cause of water quality problems, according to EPA's review of state reports. So it was section 319 that laid out the non-point source management program, and we'll talk more about that on the next slide. So under the program, states make certain assessments about their water bodies within their jurisdictions, and they develop programs to help manage non-source pollution. Then they phased in those programs. There's federal funding for states under section 319H. And so the states would submit a funding plan to EPA. EPA determines if the plan meets the eligibility needs requirements. And then if so, they go ahead and issue some funding. And the states may be surprised, they can include more than just controls. They can include technical assistance, education, training, technology transfers, in addition to their regulatory programs and financial assistance to help get some pollution controls in place. So the Coastal Zone Act reauthorization amendments, I believe those were in 1990, established the coastal non-point pollution control program that EPA administers with NOAA, that's the National Oceanic and Atmospheric Administration. So that program addresses non-point source pollution problems in coastal waters. And under section 6217 of that act, states and territories are required to approve coastal zone management programs to develop coastal non-point pollution control programs. And those programs are supposed to include non-point source pollution controls. So the states really, while the federal funds this program, federal regulations really apply to point source. So there are kind of, I think Robin mentioned that there's ways to, a lot of this is incentivized, providing money, providing the tools. And another way to help get some more additional non-point source control is effluent trading programs. So these are similar to, if you think of carbon trading programs, they allow for commodities to be traded between regulated entities. Here it would allow for commodities to be traded between regulated and non-regulated entities. So under, I think some states have had these programs where under the programs, the facilities with the NPDES permitted discharges, they'll be facing higher pollution control costs, and they might be able to meet their obligations if they purchased, equivalent pollution reductions from other sources. It might be a lower cost to them, and that could be a non-point source. So that would then incentivize a non-point source to maybe somehow, some way control so they don't need their reductions, and they can sell those reductions to the regulated entity. So one way that a regulated and non-regulated entity may seek to trade is with regard to total maximum daily loads. Next slide. So TMDLs apply to impaired waters. States and territories and tribes, authorized tribes, submit lists of waters that are too polluted or otherwise degraded to meet water quality standards. So that's what I spoke about earlier about these, these standards are based on the designated use, anti-degradation policy, and they underlie the water quality-based effluent limits within the permits. And so these are known as the 303D impaired waters lists. The NPDES permitting authority develops and implements the TMDLs. And so, and as you already know, the limits are included. The TMDL limits can also be included in the NPDES permit if the water body is impaired and has a TMDL limit established. So the main goal of the TMDLs is to attain or maintain water quality standards, and it's pretty much a pollution budget, just like a lot of our pollution systems. It's the permitting authority calculates the maximum amount of pollutant that can occur. This is in a water body, and allocates reductions to one or more of the sources of pollution to stay safely under that maximum amount. So where there's a TMDL that is for waters that are for more than one state, the most stringent state water quality standard applies. So if EPA does look at these at the state developed TMDLs, and if EPA disapproves a state TMDL, EPA must develop a replacement TMDL on its own. And next slide. So here is how the TMDLs are calculated. So the TMDLs are developed for each pollutant typically. So if there's 3 pollutants impairing a single water body, that water body could have 3 TMDLs. Alternatively, there could be an instance where one TMDL may be able to address multiple pollutants. So looking at the formula here, so you take the sum of the waste load allocations. So that would be all of the existing point sources subject to NPDES regulation. You add that to the load allocations, which would be all the non-point sources and natural background. And then you add a margin of safety. So you can take in account for seasonal variations, you should, but the margin of safety itself takes into account any lack of knowledge concerning the relationship between the effluent limitations and the water quality. So sometimes there's a lack of knowledge as to non-point source pollution. So there's a margin of safety built into that. I've underlined here daily in the term total maximum daily load. So there's been litigation over TMDLs, but then particularly over the interpretation of daily. So the DC Circuit has allowed for a total maximum daily load to be set for how much can enter the water body on a given day, yet has allowed in the same instance that another measurement, such as the seasonal average, sets the time frame for which you have to meet that daily maximum. So, so when you think of daily, it might not be as transparent as you might initially think. And some circuits may have come out a little bit different on that. So that's pretty much all I have for you guys today. And I was not watching to see if there were questions, but I can.
Oh, thank you very much, Erin. Yes, we've had a lot of questions rolling in, and with our 20 minutes remaining, we will try to get to as many of them as we possibly can. I'll actually start with Chandler, if you want to explain the availability of the recording for this.
Yes. So the recording will be available online at ELI's website on this event page. So if you're registered, you will have access. I would estimate that to be available in about 2 business days. So check back early next week if you're interested in watching the recording.
Great, thank you. So I've actually asked one of my colleagues, Becky Kisslinger, who is the head of ELI's wetlands program, to also join us because I feel like there are some questions here that she might be able to help with. And I will start with one specifically, and certainly the panel is very welcome to jump in on this as well. But the question is, can you elaborate a bit about the wetland banking and how that may be done with salt marsh areas, for instance? And Becky, are you able to speak?
I'm here. Can you hear me?
Perfect. Yes, great.
Okay. It's asking me. Well, okay, I'll just go ahead. Thank you. I'm sorry I joined a little late. Thank you, Adam, for inviting me. It's a great question, and I'm not seeing the presentations. I'm just going to start a little bit at the beginning, but try to go quickly. So wetland mitigation banking is one of the ways that a permittee can satisfy their compensatory mitigation requirements under their Section 404 or their state permit for impacts to wetlands and waters. So for a mitigation bank, the banker will enter an agreement with the Army Corps of Engineers and the interagency review team. That agreement is called their banking instrument, and that lays out their plan for restoring, enhancing, and sometimes preserving a site that for which they will then be able to sell credits to permittees for their compensatory mitigation requirements. So once the banker has met the laid out requirements in their instrument, they are allowed to sell those credits to permittees. And those credits are based on the kinds of resources that they are restoring. So that could be a stream, a non-tidal wetland, a salt marsh wetland, and then the functional lift that they're providing through the restoration. So those credits can be, and so your question was specifically about salt marsh. So they can, a banker could restore a site, a salt marsh site, and provide salt marsh restoration credits on the market for impacts to other salt marsh wetland areas. I did a quick, after Adam wrote me, I did a quick look at the U.S. Army Corps' Ribbit site, which catalogs all the different banking sites and what kinds of credits they have. And there were a number of salt marsh mitigation banks. So they are out there, and there may be more than I was able to pull up, but those would be opportunities for a restoration area that would be funded through the sale of compensatory mitigation requirements to offset impacts to those sites. Adam, do you want me to expand on anything, or does that sound?
I'm actually wondering if you're able to send me the Ribbits.
I can. Yep.
Yeah, URL. I'll put that in the chat.
Awesome.
Does anybody on the panel want to expand on that? Any comments in that regard? Okay, we'll go to another one that is related while I've got you, Becky. How effective are these wetland banking, and also the questions about effluent trading programs? How effective have they been? Examples and opinions. And so I'll start with wetland banking, and then we'll move on to effluent trading.
Sure, that's a complex question. So I think historically there was some concerns about the ecological success of compensatory mitigation in general and mitigation banks specifically. And then in 2008, the Army Corps of Engineers and EPA finalized regulations to try to improve the administration and implementation of all forms of compensatory mitigation. And so that required that there were financial assurances to ensure that the compensatory mitigation projects were actually occurred and met their performance standards. They have requirements for monitoring and long-term management and adaptive management, and that was meant to really improve the practice. There haven't been a lot of good comprehensive nationwide studies since those rules were finalized more than 10 years ago, coming on 15 years ago. But I think that practice has certainly improved, and there's more studies showing that at least administration of mitigation banks and inland fee programs are following the requirements in the regulations. But with regard to the ecological success, I think that more study is needed to show how those sites are faring on the landscape, and the restoration of these kinds of systems is very complex and takes a long time to get to where you can see actually how they're going to function over time. So we're just getting to a point where I think those studies would be extremely valuable.
Thank you. And thank you for being with us, Becky.
Sure.
Looking to the panel with regard to effluent trading programs, whether Aaron or anybody else, would anybody like to comment on how effective they have been?
I actually don't know how effective they have been, but I do know that there have been, I think, government evaluations and as well as private evaluations that can likely be found online to find out a little bit more. The EPA is still, I guess, supporting those. They have issued some resources, guidance documents, frequently asked questions, and things of that nature. So in my mind, there's still a tool that at least the agency thinks is useful.
I could piggyback on that, and I'll say this is not my area of expertise, but I could just make a couple general points, which is, so the Clean Water Act, as Aaron said, allows for water quality trading. We also see this, for example, under the Clean Air Act. And I think two issues that are challenging under the Clean Water Act is one is the fungibility of discharges. So a certain amount of pollutants discharged in one location does not have the same effect on the environment as it being discharged in a different location. So there needs to be a sort of scaling in order to preserve watershed quality that is technically difficult to achieve. Another point that is relevant, not just in the Clean Water Act, but we could also see this in some areas of the Clean Air Act, which is an environmental justice focus, which is that if you allow trading, there could be the concentration of pollution hotspots. And perhaps if we think about like carbon emissions or carbon trading or greenhouse gases, there it sort of doesn't matter where the carbon is emitted, because it's not having a negative impact right in that immediate vicinity of emission, but it's having a global impact on climate change. But for water or other forms of air pollution, that is degrading environmental quality in the immediate vicinity of the discharge. And so even if you could work something out that was mathematically correct and kind of leading to overall maintenance or improvement of water quality, that doesn't mean that within each location in the watershed or each population living in the watershed would necessarily benefit from a water quality trading.
And this is also not my area of expertise, but I will say, since the question I was asking for examples, I feel like most of the examples to date have concerned temperature impairments, and that particularly looking at Oregon, and there's some examples there that I think are some of the most longstanding. Okay, Trying to get to some of the other questions. Are forest roads and forestry activities only covered by NEPA? They appear to be excluded from the Clean Water Act. Any answer to that?
Well, the Clean Water Act is dealing with discharges of pollution to navigable waters. If we think about the 404 permitting, there are some exemptions for forestry activities. But I guess beyond that, I don't fully understand the question.
I think it's asking what exemptions there are to forestry activities under the Clean Water Act.
Well, and so those are mostly related though, not to road construction within national forest lands, but ancillary to various silviculture activities. Some debris could end up in a waterway. And if that is at a de minimis or like kept to a minimal amount, that does not require a permit from the Army Corps of Engineers. I'm not sure if I'm responding to the question, but.
No, I think that helps. Any other comments on that one? Okay. Assuming NEPA applies to the EPA established effluent limits, the EPA established effluent limits, how does the economically achievable criteria balance with the other criteria of NEPA, which also includes economic feasibility?
Well, I feel like I'm talking a lot. I'm going to say this and then I'll be quiet. Okay, so NEPA applies to major federal actions that could impact the environment. However, there are some exclusions under NEPA, and one exclusion is for activities that the EPA conducts under different environmental statutes. And so the EPA's setting of effluent limitations under the Clean Water Act is not an activity that is subject to NEPA review, because the idea is, well, it's already happening under the Clean Water Act. The Clean Water Act and the Administrative Procedure Act allow for the public to provide comments on that proceeding. And so it's outside the scope of NEPA entirely.
Any other comments on that one?
I was curious about this, so I was looking it up in between, and one thing I came across was that the Clean Water Act sets out that that NEPA only applies to, I think, EPA issued NPDES permits for new sources, so fairly narrow there.
Excellent. Thank you for the on the spot research. And actually, Jonathan, while I've got you, going back to the question that I had been mistyped, does the proposed Clean Water Act regulation include discussions on playa wetlands, particularly those found in the arid Southwest? And I think this goes back to WOTUS rule.
So yes, it does. I think it's important to remember that under the Navigable Waters Protection Rule, the agencies estimated that almost 90% of streams in the arid West would lose protections. And I think, you know, there are similar losses for wetlands in the arid West as well. I took a look back at the actual proposal that EPA came out with. And so it includes, it specifies playa lakes as an example of waters. And there's kind of two ways they could come into jurisdiction. One is where the use or degradation or destruction could affect interstate or foreign commerce, or where playa lakes or other waters meet either of the two Rapanos tests, either the relatively permanent body of water with a continuous surface connection to another jurisdictional water, or where alone or in combination with similarly situated waters, they have a significant effect on the integrity of jurisdictional waters. And also, just turning back to that earlier question about similarly situated, I don't think Kennedy gets in the details of what that means. The post-Rapanos agency guidance from EPA sets out one example where they say all wetlands that are adjacent to the same tributary are considered to be similarly situated, and they point to the integral ecological relationship between a tributary and its adjacent wetlands.
Excellent, thank you. Any other comments on that one? So I had a bevy of citizen suit questions. come through. One of them was, can a state agency action preempt or prohibit? Nope. Oh, this is the one I wanted to ask. Here we go. All right. Can a state intervene in a citizen suit at all? That's the first one I want to ask.
Yes.
And what happens to pending citizen suits when that happens?
Yeah, so I mean that, and I welcome the other panelists to jump in, but I think this is, known as overfiling. And so, you have to send a notice of intent to sue 60 days before actually filing suit in a citizen enforcement. And so that gives the state the opportunity to quote unquote overfile or file their own enforcement suit. I think alternatively, the state could attempt to intervene in an ongoing and active citizen enforcement suit after the complaint had been filed. The question asked if when a state agency is a named defendant in the citizen suit, how can the agency intervene? So, I think they would already be a participant in the suit by being a named defendant. Yeah.
Any other comments on that one? All right, going back to one of our earlier questions, and I appreciate, Raymond, your addition in here, and I just want to flag it for everybody. There's a note that Section 404 requires the Corp of Engineers to comply with NEPA before issuing permits, while Section 402, which is administered just by EPA, does not. 402, definitely some states have designated authority under 402, but most do. Anyway, so wanted to get, let's see, we got about 4 minutes left. Is there any desire to work with FEMA's NIFIP program, NFIP, to ensure that floodplain development does not result in increased TMDLs, especially adjacent to impaired waters? Understanding this should be done at the state level, but is there an effort at the federal level to assist in the coordination, as water quality and floodplain development are not always in the same state offices? Robin, I'm particularly looking at you, but anybody could answer.
I don't know if I have anything useful to say other than this is a very insightful comment. So the NFIP is the National Flood Insurance Program, primarily relating to nationally subsidized flood insurance for development occurring in floodplains. And we could have a long conversation about whether it actually encourages development in floodplains or not. I am not aware of an activity that is linking the NFIP and TMDLs, but I think this is a brilliant idea. Maybe can I punt to Erin?
Yeah, I'd have to say I'm not fully aware, but I do know there is a lot of coordination with FEMA and EPA. We even deploy with FEMA as part of our, we can do deployment details with FEMA, and even colleagues have gone to work with FEMA at the time for years. So there is coordination. I don't know specifically on this point, but I would, I'm trying to, yeah, I guess that's all I really have to say about it. It's definitely not my area of expertise, but there may be something there.
We could make a broad point, which is that we're often talking about the conversion of agricultural land into urban development. And it is not a foregone conclusion that that transition is bad news from the standpoint of, say, nutrient loading, which could be covered by a TMDL. We could talk more generally about urban sprawl or where we should encourage growth. But in fact, urban development may result in a reduce of nutrient loading and support the TMDL objectives.
And I'll also add, it's funny this comment comes up, this question comes up, but ELI is going to be putting on an event for state water quality staff and tribal water quality staff, specifically focused on trying to help with that, them better understand FEMA's programs and get better connected with their own state hazards folks, and being able to, so it's not directly on point, but it is trying to improve this connection and identify resources and identify some case studies, examples of ways in which this has worked pretty well. So there are efforts going on to try to help with this, but it is something that is certainly a need. All right. We're at the end of our time. I am sorry I did not get to all the questions. There are a lot of really phenomenal questions in here, but I just want to say with our last 30 seconds, thanks again, Aaron, Jonathan, Robin, very much for your presentations today. Thanks to all of you in the audience for some phenomenal questions, as well as your time and your attention today. And yes, as Chandler said, the recording for this will be available on ELI's website probably in the next couple of days. And again, thank you all very much.